So the California magazine ban case Duncan v. Bonta is now up for Supreme Court review. So let's talk about this. But real quick before we jump into this video, if you think there should never be a ban on standard capacity magazines, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, I have an important update for you all in the California magazine ban case known as Duncan v. Bonta. The plaintiffs in this case, along with the California Rifle and Pistol Association and the NRA now, have filed a petition to the Supreme Court. For those of you who are not aware, Duncan v. Bonta, previously known as Duncan v. Becerra, involves the possession of so-called large capacity magazines in the state of California. California Penal Code Section 32310 bans the buying, selling, possession, etc. of magazines that hold more than 10 rounds, and it bans ordinary citizens in the state from having those magazines. This case was primarily brought and litigated by CRPA, but now you have the NRA finally jumping on, and they are filing this lawsuit or seeking a petition for Supreme Court. Now, some procedural background. This law was challenged in the Southern District of California, and a district court judge, Roger T. Benitez, or Saint Benitez as he's become known as, issued a ruling that found that this law in California did in fact violate the Second Amendment. This ruling led to what is known as Freedom Week in the state of California. During a single week period of time when this magazine restriction was lifted, millions of magazines were purchased and brought into the state of California by California gun owners. The state of California obviously did not like the Benitez ruling, so they decided to appeal his decision up to the Ninth Circuit. A three-judge panel in the Ninth Circuit reviewed the decision of Judge Benitez and ultimately did agree with Benitez, finding that this was a violation of the Second Amendment. Well, after that, after California lost once again, they sought a rehearing en banc, which means review from 11 judges in the Ninth Circuit. The en banc panel in the Ninth Circuit heard this case and issued their ruling finding that the California magazine ban does not violate the Second Amendment. In reaching that decision, the Ninth Circuit used the flawed two-step approach and found that under intermediate scrutiny, this law was constitutional. That therefore leads us to here and now, where you have the plaintiffs in Duncan seeking Supreme Court review. So let's take a look at what they present to the Supreme Court in this petition and what they present on why the Supreme Court needs to hear this case. So this petition seeks to hit on three major issues. First and foremost, it seeks to have the Supreme Court address whether an outright magazine ban, which also has a retrospective confiscation component in it, is a violation of the Second Amendment. Second, the other thing that they want to address is whether a ban that requires people to turn over magazines to law enforcement, destroy them, or to permanently alter them is a governmental taking. And finally, the plaintiffs seek the Supreme Court to review the Ninth Circuit's incorrect two-step analysis approach, which the Ninth Circuit frequently uses to uphold these types of Second Amendment violations. So those are the three main things that they want the Supreme Court to address if they decide to take up this case. Now, I want to read to you the introduction of the argument section of this petition because I think it beautifully sums up what the issues are in this case, how nasty this law is in California, and really how grotesque it is that the Ninth Circuit en banc panel continues to uphold these types of laws. The petitioners state, California's retrospective and confiscatory ban on magazines capable of holding more than 10 rounds of ammunition is unconstitutional twice over. The Ninth Circuit acknowledged that such magazines are commonly possessed by law-abiding citizens for lawful purposes. Indeed, they constitute fully half of the magazines in the country. These are standard issue magazines owned by millions of ordinary law-abiding citizens. The court assumed that such magazines are protected by the Second Amendment. But just as in every other case in which the Ninth Circuit was willing to make that assumption, it made no difference. The Ninth Circuit held that these utterly commonplace and constitutionally protected magazines not only can be banned prospectively, but can be confiscated without running afoul of the Second Amendment. As the district court, the three-judge panel majority, and the dissenting judges on the en banc panel all made clear, California's radically overbroad and confiscatory law could not be sustained based on anything even resembling actual heightened scrutiny. Flat bans are the very model of overbreadth, and confiscatory efforts to wrestle from the hands of law-abiding citizens constitutionally protected property that was lawfully obtained and has been safely used for decades goes beyond mere overbreadth to ignore the basic relationship between the government and the governed. There is no constitutional tradition in this country of the government simply declaring items lawfully possessed for decades to be contraband, let alone items that the Constitution explicitly entitles the people to keep. The decision here aptly captures the lower court two-step that proceeds in the name of heightened scrutiny, but inevitably 50 times out of 50 upholds even draconian restrictions on a fundamental constitutional right. This has to stop. This mode of review undervalues a basic constitutional right, here two constitutional rights, and sows disregard for the Constitution and the court's precedents. But the en banc court made crystal clear that it will not refrain from assuming the Second Amendment is fully applicable and then finding it is entirely toothless, unless and until the Supreme Court tells us to stop. This court should accept that invitation. So there the plaintiffs are pointing to the reality of the situation in the Ninth Circuit and what the en banc panel in the Ninth Circuit has been doing. 50 times out of 50, the Ninth Circuit's en banc panel has upheld restrictions on the right to keep and bear arms. In these cases, the Ninth Circuit always states that the item is protected by the Second Amendment, but then goes on to say, well, under their two-step approach, the item can still be banned or restricted by the government. Even worse, on this specific issue, not only did the Ninth Circuit say that California could ban magazines, but they could retrospectively ban them and then confiscate magazines that are already in lawful possession of the people. In their first argument section, the petitioners state that Heller has established when a court confronts a flat possession ban on a type of arm, the only question is whether it is an arm typically possessed by law-abiding citizens for lawful purposes. If the answer is yes, then the ban is unconstitutional because a state cannot flatly prohibit people from possessing what the Constitution entitles them to keep. California's ban on the acquisition and possession of magazines that account for approximately half of all privately owned magazines plainly flunks that test. Magazines are indisputably arms protected by the Second Amendment, as the right to keep and bear arms includes the right to keep and bear components such as ammunition and magazines that are necessary for the firearm to operate. On that basis, the petitioners argue that that should have been the end of the inquiry. In the second main argument section, the plaintiffs argue that the en banc panel's taking clause decision is inconsistent with the Constitution and constitutional law. The panel held that California's ban affects no physical taking because the law allows property owners to modify or to sell their property, rather than having to absolutely surrender it. The plaintiffs argue that none of these so-called options provides a viable way for ordinary, law-abiding citizens to keep their constitutionally protected property, and therefore there was clearly a taking. Finally, the last argument they make in the petition is that the Supreme Court needs to strike down the Ninth Circuit's two-step approach that it has used and has always used to uphold these types of violations. They argue that this type of analysis that the Ninth Circuit is using is exactly the type of analysis that Heller rejected in its decision. Based on all that, the plaintiffs argue in their petition that the Supreme Court should take the Ninth Circuit up on their offer and confirm that the Ninth Circuit has fundamentally misunderstood the basic framework for assessing Second Amendment issues. So this is a case we all anticipated would likely find its way up the Supreme Court. Whether the Supreme Court takes it up is unknown at this time. The Supreme Court has put on hold a similar magazine ban case, the ANJ-RPC case. However, in my opinion, Duncan is a cleaner example of how lower courts and states have run amok on these types of issues. So that is where the Duncan v. Bonta California magazine ban case stands as of right now. If we get any other updates, I will definitely let you guys know. If you have any questions, go ahead and comment down below and I'll try to answer to the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I cannot thank you guys enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought. So thank you so much for all of your support. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars. This nation will be maintained by armed scholars.